Hi, everybody. Welcome to the very first Art of Estate Planning Facebook Live for 2021. So it's great to be back, and I thought I'd let everybody know that we are moving to a monthly Facebook Live schedule from here on in. We have an amazing knowledge bank of previous lives from running them every week or so from the last couple of years, and they're all saved under the units section in the group. So now that we have got that sort of knowledge bank stored up, we're moving more to a monthly schedule just so that everyone can attend the Facebook Lives in person in real time, and that we can be really targeted with our topics as well. So I'll just double check that we're broadcasting. If you're watching, let me know how the tech is working. I've got the fancy microphone that I borrowed from my husband. If it's coming through loud and clear, it'd be great for you to let me know if there are problems. Now's a good time so we don't go too far. Okay, and I'll just check. I'll give it a minute just to see some comments pop in. I can see there's a few of you watching live, so thank you so much for making the time to join me in real time. Yes, amazing. Thanks for giving me that feedback. Today's topic is all about the New South Wales Foreign Person Surcharge and how it applies to testamentary trusts. Now, I'd love to know who watching is in New South Wales and who is not in New South Wales, just to get a little sort of check. Because my first question is, who the hell cares? Especially, why do I care? Because I'm in Queensland. Occasionally I work with clients in New South Wales, but I mostly work with Queensland clients, right? So why am I so worried about this? Because I can tell you, I've got a bee in my bonnet about this issue. I've been emailing David Durham at Lexon, which is the Queensland Professional Indemnity Insurer. I've been emailing my friends on the Queensland Succession Law Committee about this because I cannot understand why it's totally under the radar. Oh, great. Oh, we got a few New South Wales people, Queensland. Okay. So New South Wales people, you guys are probably all across this, right? Because it's your legislation. You've known about it for months and months. This is mostly for the people who aren't in New South Wales, actually. But I think it'll be interesting. I'd love to hear your input as we go through. And I think hopefully you do learn something from today, or it's good to just compare notes on how we're dealing with this. But for the people who aren't in New South Wales, you need to give a shit about this. It actually is relevant for us as well. And I want to make sure that this is on every lawyer's radar if they're preparing testamentary trust wills and they're in the Art of Estate Planning group. Okay, and I'll also have a little disclaimer. I am not professing to be an expert in New South Wales land tax or stamp duty. What I'm here doing is just sharing what I've discovered in my research, and I'm really open to hearing from particularly New South Wales lawyers who have practical experience about applying for these exemptions, how they work, to sort of, overlay any kind of practical guidance that you might have that I might have missed. So please do shout out in the comments if you feel like, yes, technically that's right, but in practice, this is what happens, or something like that, that I'm really not giving due respect to, because I do want this to be more of a conversation than me giving a lecture. So, okay, thanks everybody for letting me know where you're based. Let's get into it. Land tax. This is like 101 back to basics of New South Wales land tax, and I've just grabbed a little screenshot from their website. So basically, if we focus on 2021, once you have land over the threshold of, for this year, 755,000, then land tax is payable. There are exemptions, so there's principal place of residence exemption. If you're an individual owning your residence, you don't pay land tax on your principal place of residence, of course, but if it's an investment property or your residence is held through a trust or a company, you're going to be up for land tax. So it's $100 plus 1.6% of land above the threshold of $755. So, if your investment property is worth $1,055,000, then you only pay it on 1.6% of the $300,000 excess above the threshold plus the notional $100, right? And then you get into that premium threshold. So that's land tax 101. What this presentation is about is the foreign person land tax surcharge that can apply. So if it applies, then it's 2% on top of that base rate surcharge. And there's no tax-free threshold. So if your investment property is over $1 million, or like, what did I say, $1,055,000, then it's 2% on that whole value, not the amount over the threshold. Again, there is a principal place of residence exemption and there's a 2-year deceased estate exemption. So I'll talk you through that, but I want to just give you some practical examples about why this is relevant, right? And I have an accounting degree. I did it years ago with my law degree, but I'm sitting here going, well, 2%, that's not much. What about 1.6, blah, blah. It's actually a ton. I put the values into the New South Wales land tax calculator, and I wanted to sort of demonstrate what this means in dollar terms. So let's say there is $1 million investment property in New South Wales that is residential related land. The basic land tax that would be payable every year is $4,000. If the foreign person surcharge is payable, add an extra $20,000 on top of that to bring your annual bill up to $24,000. So to me, this is significant. If we are going to be preparing documents where we're exposing the client unnecessarily to an extra $20,000 bill each year on an investment based on the ownership structure that we've set up for them, I think we need to know about that, okay? And we either need to avoid that or get their consent or be aware of it. What I'm worried about is lawyers just inadvertently putting their client into a structure that attracts this penalty surcharge without realizing. Now, and I mean, $1 million, I picked that just as a round number. And I know for some clients, that's going to be nothing, particularly if you're talking about inner Sydney kind of values, that's nothing. But, for other clients, they could be crazy. And you're like, well, who's got all these $1 million properties? So I wanted to just show you how it works on properties that may not even attract land tax. So on the right-hand side here, I went for the $750,000 value, which you might recall is less than the land tax threshold. So you'll see here, they're not going to pay any land tax. They're not used to paying land tax. They're not expecting to pay land tax. It's below the threshold. But the 2% surcharge, $15,000 straight up every year, not just 1 year, every year. If you've got a $500,000 property, that's 2%. That's going to be $10,000 bill every year. So say you've got your little investment unit and, okay, they factored in body corporate and their rates and their water and insurance and all of that. And then suddenly there's a $10,000 bill on top of their modest $500,000 investment property. Hello, if I was a client and my lawyer put me into this structure, I'd be contacting their insurer. So I just hope that this gives some kind of context about this is a trap that I think as lawyers, we can, I don't want us to fall into. And financial planners, accountants, for those of you who are watching this as well, this is really important to be on your radar as well. I think just to know that there is this issue floating around. If your lawyer is saying we need to be excluding foreign people as beneficiaries, this is why. If they're not bringing it up, maybe ask the question, okay? And then also going forward, understanding how we manage this risk for clients as part of planning. So basically, we had all of these amnesty provisions until 31 December 2020. So from 1 January this year, we're in this new world where wills signed after that date need to manage their risk exposure to this. Same with trust setup, all of that. So let's land tax. Let's talk about stamp duty. So obviously stamp duty is paid on the acquisition of real property in New South Wales by the purchaser. So if you're a foreign purchaser, there's an extra 8% of market valuable duty. 8% of duty payable on the market value of the property, okay? So let's have a look at some calculations there. 8% of $1 million is $80,000. So, and it's on top of, it's not like, okay, well, you've got a new rate of duty, which is 8%. It's an additional 8%. So like on $1 million property purchase, your normal duty would be 40 grand plus the foreign purchaser surcharge of 80,000. Our duty bill actually went from $40,000 to $120,000. What? This is significant. Even if your purchase price is $300,000, right? That's modest. You might have, your first kind of investor or whatever there, and they were having a, under 10 grand duty bill. Extra $24,000. This is significant. You do not want your client to be inadvertently paying these land tax or duty rates if they don't have to. So obviously the land tax is recurring annually for as long as you own the property, calculated at the end of the year, and stamp duty is a one-off purchase tax. Okay, so hopefully that just sort of brings home why we need to pay attention to this. So how does it apply to estate planning, I hear you asking? All right. Discretionary trusts and testamentary trusts are basically going to be treated the same from the 1st of January this year, which is why I had a little bee in my bonnet about why aren't we hearing about this from our professional bodies? Why didn't the Lexon update the last week of December mention that we need to know about this? I think nobody really is aware of it because they just think it's a New South Wales issue. How's it relevant? There was one little article sort of alluding to it in our Proctor in Queensland, which got it on my radar, and also big thanks to Chris Herald for saying, what the hell are you doing about this? Because it was I didn't know about it, or I wasn't paying attention to it either, thinking it was just a New South Wales problem. And honestly, land tax, stamp duty, it's not something that you get excited about trying to keep up to date with. So let's go 101. How are discretionary trusts being treated with respect to this Land Tax and Duties Act? I've summarised the impact of Section 5D of the Land Tax Act and 104JA of the Duties Act. They almost are mirror image. So this foreign owner surcharge will apply to the trustee of a discretionary trust if it owns New South Wales residential related property, unless no potential beneficiary of the trust is a foreign person, and it's double entrenched. So you cannot vary the deed to allow a foreign person to be a potential beneficiary. This concept of potential beneficiary is really important, where I think New South Wales is going way beyond the other states. And again, I don't have a neat little table for you saying which state, how they're all dealing with this. But for instance, in Queensland, we have similar provisions, but it's the takers in default can't be a foreign person. So generally, like most trusts would say, well, the primary beneficiaries are the takers in default. As long as there's no foreign beneficiaries in the primary beneficiary or takers in default definition, you're right. Here, it's no potential beneficiary of the trust at all. So really looking at, well, who's included in all of those extended definitions, and not even who is there today at this moment, just the fact it's potential beneficiaries in the future. So if you want to have a look at this, have a look at this practitioner, the Commissioner's Practice Notice, 004 version 2. It goes through this in detail, and I've just screenshotted a couple of the paragraphs here, so you get a context of how expansive this requirement is. So basically they look at you can't have more than a 20%, I think it's 20% maximum percentage interest. So that's relevant when we've got companies and unit trusts, and also tracing through structures, because it does trace through. For a discretionary trust, obviously no beneficiary has a fixed interest. So they've said every beneficiary is deemed to have the maximum interest over which the trustee has discretion. So automatically, it's like every single beneficiary is deemed to have a maximum interest in the trust, regardless of whether they've ever received a distribution or not, regardless of what class of beneficiary, whether they're a default beneficiary or not. So this is serious. You basically, the only way to avoid it is to flat out exclude any foreign person from ever being a beneficiary, and double entrench that so that the variation power can't be varied to change it. Testamentary trusts. So that's the position with respect to discretionary trusts. Here's the position for testamentary trusts. There was an amnesty, and they basically said if you signed your will or codicil before 31 December, no wuckers. You don't have to exclude your foreign people as beneficiaries. There's an exemption, you can relax. But unfortunately, all your clients will be signing their wills after that date now, so we have to pay attention. With respect to interstate beneficiaries, I'm not going to go into that with the rules there or the court orders, but just note that there's slightly different rules there, but that's not really in the context of testamentary trusts, at least the intestacy isn't. This presentation today is about lawyers preparing testamentary trust wills for their clients. So anyone who signs their will from 1 January onwards this year needs to pay attention. Who are foreign people? It's defined basically to refer you back to the Foreign Acquisition and Takeovers Act, but they do, the test is a little bit easier. So that act, as I understand it, requires you to look at how many days a Australian citizen who lives overseas has been in Australia, and it's all of that. They've taken that requirement out. So if you're an Australian citizen, ordinary resident of Australia, you're cool. You're not a foreign person. There's a revenue ruling on this, G009, and it goes through really extensively who's in and who's out. So I suggest you have a look at that if you do have a client scenario where they're not sure. The other thing I'll just mention is when we're looking at a beneficiary's interest in a trust, we're tracing through the different levels. Or so if a trust that has if there's a company which is owned by a foreign person and it's a beneficiary of the trust, then it's still relevant and traced through. And that's also explained in this ruling. So let's have a chat about testamentary trusts. And I'll just make a comment there for the New South Wales people watching. If there's anything that I've said so far that you don't agree with or isn't quite playing out that way in your experience in practice, I'd love to hear it, please. So let's just refresh ourselves on the life cycle of administering a testamentary trust and where these different land tax and stamp duty costs apply. So obviously the testator dies owning residential related property in New South Wales. There is a 2-year land tax exemption for administering the estate. There's a requirement then, obviously, the property is transferred from the deceased to the legal personal representative. And that is a dutiable event, but the exemption in Section 63 says, well, it happens because of the death of a person under a will, so it's exempt. And then Section 63 also applies when the legal personal representative transfers it to the trustee of the testamentary trust. So then once the asset is in the testamentary trust, the trustee just manages that asset. Obviously, there's decisions made to either like hold the investment or to sell the investment. We would assume in this case they're holding the investment, from which land tax is payable each year. Now, overlaying that is, does the principal place of residence exemption apply? Usually not with respect to a trust, but I do think there's an exemption if the will gave the person living in the property, the beneficiary living in the property, a right to occupy. If someone in New South Wales wants to correct me on that, let me know, because I've only looked into that a tiny bit. The next kind of event that could happen is the trustee purchases more property in New South Wales and stamp duty would be payable. So we've got some questions here about how does the foreign person surcharge apply with respect to this? Does Section 63 apply to the exemption of, does Section 63 exemption apply to foreign surcharge? When would these surcharges kick in? So, in respect to Section 63 exemption, the ruling there does talk about a couple of things. Firstly, this is a useful paragraph to know. It's like right at the back of the document, kind of a bit hidden, and I've seen people overlook it before. So obviously getting property into a testamentary trust is going to access the exemption in New South Wales, but getting real property out of the testamentary trust will not. Just so everyone's clear, that's an anecdote, not really related to this topic. So revenue ruling DUT 046 refers us to revenue ruling GO10B2 in relation to surcharge purchaser duty. And in my interpretation of this is that it does extend the the deceased estate exemptions to foreign purchaser duty. So it basically, if the trustee acquires the New South Wales residential related property under the will and the deceased was not a foreign person at the date of their death, then the commissioner may exempt the section or apply the Section 63 exemption from surcharge purchaser duty. Great, that's a win. What about land tax? If the deceased was not a foreign person at death, then no surcharge duty is payable on the principal place of residence. The commissioner might also exempt this on other land, but only for 2 years. So basically the 2-year exemption also applies. So looking at this in the context of estate planning, those numbers I showed you before, maybe they're not so drastic. It's not like we're getting hit with 2 lots of that foreign purchaser surcharge duty. And in fact, you should be able to get the property into the testamentary trust without any foreign purchaser surcharge duty. It would only be on the acquisition of future properties. So I've tried to put this in a little table for you. You know, if we're getting, we should be able to rely on deceased estate exemptions that already exist to get the asset into our structure. But going forward, our testamentary trust is not going to be particularly useful. So this is kind of like once the estate admin process is finished. So if it's the principal place of residence, I think my interpretation of GO10O is that if it was the principal place of residence and there's no foreign people involved, then you're not going to get hit with that extra annual land tax foreign foreign person surcharge duty. But if it's an investment property, you've got 2 years for administration and then it applies thereafter. So this is a problem. Everything in pink is a problem, in my opinion. And if they want to sell an asset, sell a property, or acquire New South Wales residential property using that trust on the assumption that it's an ongoing wealth accumulation vehicle, then they are going to be hit with that surcharge. So basically, you wouldn't buy any New South Wales property in that testamentary trust. It's useless with respect to New South Wales property. And yes, maybe you could avoid the annual foreign person surcharge by selling that asset and buying a different type of asset that is not New South Wales residential related property. So there's ways to manage this, but it would be an almighty stuff up if your client had to deal with this issue and they weren't aware of it and you didn't have it on your radar. So this is my interpretation of where the risks are and the practical consequences of these new rules. Solutions. I didn't come here just to give you problems, and this actually reminds me of when I was a young grad, or maybe I'd been admitted a year or two, but I was still very young and I was working at McCullough Robertson in Brisbane, and I had to send an email to the managing partner explaining how something that he'd come up with didn't work, and he'd sent it to our team to sort of 4i it, and it didn't work. And I sent him an email saying it didn't work, and he called me. And I was struck with a lightning bolt of terror seeing the managing partner's name flash up on my screen. And I picked up the phone and he just said, "I need solutions, not problems," and hung it up. And lesson has stayed with me ever since. So I bring to you some solutions. More than let your intuition guide you, I have some real practical solutions. Okay. Let's start with the basic case. If the will was signed before 31 December last year, chill, you've got an exemption. Although I think if you've got a client who wants to update their will or sign a codicil, I think that exemption may not apply. It's actually unclear what happens if they sign a codicil. I don't know. I would be taking the conservative approach or getting a ruling. Next question. Does your will maker live in New South Wales or own New South Wales residential related property? And so this is probably the position for most of the New South Wales lawyers, which I suspect you've just resigned yourself to and made it part of your practice. But also relevant for lawyers who are acting across the border or out of their home state. Or if you have a client who lives in your home state and already owns New South Wales residential related property. If yes, then we really need to sort of ask ourselves, is the client comfortable that these vehicles exclude foreign persons as beneficiaries? So this testamentary trust is meant to be, in my opinion, an intergenerational wealth accumulation vehicle. They're not always. Often, there's just going to be enough wealth going in there for the family, and, maybe the money gets managed for minors while they're still young. And then once they've all reached majority, it all sort of comes out as capital distributions to help them buy a house and the trust gets wound up, right? But also a lot of these trusts are used for multiple generations. They're very powerful for tax purposes, as we know. These are the kinds of trusts and structures that keep wealthy people wealthy. So we need to ask ourselves, what is the long-term vision for this trust? If the client says, yeah, I can't imagine us excluding, needing foreign people to ever benefit from this trust, then I think option one is a fine option. And I suspect a lot of people are just defaulting to this. The testamentary trust terms will say foreign persons can never be a beneficiary, and the will and the testamentary trust can never be varied to allow a foreign person to be a beneficiary. Notwithstanding anything else in the will, no foreign people ever. Yep. Is anyone doing option one? I mean, that's probably like the simplest approach where you've got a client that it's okay with. The other option, if they've got kids, if you've got boomers who have kids kind of living overseas already, maybe having spouses from other countries, maybe they're going to have children, who knows where those children or those children's children will end up, and whether they will be foreign people, then maybe option 2 is a good approach. So this is having an additional testamentary trust just to receive that New South Wales residential property, and that trust excludes all the foreign people ever as beneficiaries, but the residue and the rest of the assets go into one or more standard testamentary trusts that don't have the exclusion. So that's probably a bit of a more advanced planning option where you can't just default to option 1. And thank you for saying, letting me know that you are using option 1. I'm just going to jump on here because I can't see who is commenting. I can just see that there are comments. Okay, so this will help me see the comments as well. Yeah, Simone, thank you for letting me know. Okay, that you are doing option 1. I suspect a few of you might be doing this as well, especially New South Wales people. I think that's just the standard. Option 3, maybe not an option, is that the client just accepts that they will have to pay the land tax surcharge. And then obviously you will be disclaiming. Can I run through option 2 again? I can. Here's something I prepared earlier, Nicole. Okay, so let's consider your single testamentary trust option. So in the standard case, if you weren't worrying about this foreign person surcharge duty, you would just set up one single testamentary trust. But you know that the testator already owns New South Wales residential related property, whether they live there or they have investments across the border or whatever. So you set up your normal will as you normally would. One testamentary trust, normal full range of discretionary beneficiaries. Then you have a specific gift of the New South Wales residential related property. And I would consider doing this as a general gift. So maybe if there's already property, put that in, describe the property, lot, title, all of that. Plus, if I own any New South Wales residential related property as defined within the Duties Act and Land Tax Act, at the date of my death, then this property also goes to testamentary trust number 2. And the terms of testamentary trust number 2 are the same, but foreign persons are not allowed to be beneficiaries, and the variation power cannot amend that ever, anytime. Does that make a bit more sense? So this, I think if you're in New South Wales, maybe this, this is your standard, and you just go, okay, we're not doing single testamentary trusts. Every will ever from now on is going to be 2 or more testamentary trusts because this is our standard approach. It probably depends on the value of your New South Wales residential related property as to whether it's worth an extra testamentary trust, and also whether the clients and you are happy to exclude foreign persons. But this could be a way, particularly in a larger estate, where the bulk of the asset or the wealth, the super, the life insurance, the family home, if they're not in New South Wales, whatever else, goes into a testamentary trust with the full range, and you're just excluding foreign persons for the asset that will attract the duty and the land tax. There's obviously some nuances around that, though, about when it's going to be appropriate and for which client. For me, I will just, do you then have some kind of equalizing clause if the residue is meant to be equal? Okay, I think I've interpreted this. So let's say you've got adult clients, you've got baby boomer clients, and they've got adult children, so son and a daughter. And in fact, the intention is they get their own testamentary trust each. So in that case, you would probably say half of the residue, excluding the New South Wales property, goes to testamentary trust number 1 for the son. Half goes to the number 2 testamentary trust for the daughter. But the New South Wales trust is a shared trust, and they probably just have to suck that up and run it together as a shared trust, which would, depending on the value of the New South Wales property, possibly make sense, if there wasn't enough. Or you could go even crazier and do a number 4 testamentary trust, which is a no foreign beneficiaries trust. And that, one foreign person trust for the son, one foreign person trust for the daughter, and they just own the New South Wales assets through these additional trusts. I would think that this is way over the top unless we're talking like a huge estate in New South Wales. But, you could do that too. So if you then, talking about equalising in the hodgepodge, if you have a beneficiary immediately known who is a foreign person, then yeah, I think you're going to have to think about how you equalise this. For me, where I'm mostly, I think I'll just take a step back and say, so if you have actual New South Wales property known at the moment and actual foreign beneficiaries who are meant to benefit, you're really going to have to come up with, think about all your options and come up with a bespoke solution for that particular situation, I think. Because even with the foreign beneficiaries, it's like, do they want an Australian testamentary trust? Should they just get the cash? There's a whole host of complex issues. What I'm thinking about here is your standard mum and dads in Australia who have no foresight that there'll probably be foreign beneficiaries. But maybe in the next, in the grandchildren or great-grandchildren could be. They've got kids who are studying overseas now and they've got no idea. So this is probably where I'm trying to think, how can we do more than just blanket excluding foreign beneficiaries, but not expose ourselves to this surcharge? I'm just going to read the comments. Oh yeah, good. Okay, great question. I'm going to come to that, Andrew. That's one of the next options. So let's get on to that. People who don't practice in New South Wales, why do you care? How are you going to deal with this? You probably care because your clients, especially if you don't practice in New South Wales, most of your clients won't live in New South Wales, but they may have an investment property in New South Wales, which is actually where we've got the biggest problems because of the land tax surcharge every year after the 2 years and acquiring more property, that trust being a useful vehicle moving forward. So it's actually probably more of a pain in the neck for us non-New South Wales people who haven't even really thought about this. And I think that our clients are going to fall into 3 different scenarios. One, it's obvious when you have your meeting and your consult with them that this is relevant because they already own New South Wales residential property. So it'll be on your radar and you're going to deal with it. Scenario B, they don't own New South Wales property. They don't live in New South Wales, but there's a chance that between the time of you preparing their will and them dying, they trot off and buy New South Wales property. And this is our problem, right? This is our problem client. Scenario C, not living in New South Wales, don't own New South Wales property now, and they don't own it at the date of the death. No worries. they're not a problem. It's only if their trust will end up holding New South Wales residential related property. How do we know if our client is scenario B or C? We don't. And this is why I'm so worked up about this, right? We have to treat every client as if they're scenario A or B, even though they could be scenario C. And this is a whole waste of everybody's time, and it overcomplicates the plan for your client. So scenario A, you're going to know that you should have on your questionnaire. I already had it on all of my questions. Do you have anything in New South Wales? Because I was worried about notional estate. Now you should still be asking that question and just be worried about land tax and duty as well. Scenario B is the sleeper, and we don't know if they're going to be falling into scenario B or if they're cool in scenario C. And your clients may not either. And as much as we say, come back and tell me whenever you buy anything, come back, they don't. And the financial planners and accountants, you guys, this is why I think it's important for you, even though you're not drafting any of these wills, have this on your radar so you can maybe catch the issue when you find out that they've gone off and bought a property in New South Wales. But I think we need to be protecting ourselves from our clients happening to be scenario B clients at the date of their death. Just a little refresher. This is the same slide as before. These numbers are pretty significant. I think 20 grand, 15 grand, 10 grand extra duty a year is a lot. If I found out I had to suddenly pay that on my little apartment in Brisbane, I'd be really pissed. So I think this is the exposure to us if we just put our head in the sand and ignore this. And as you guys all know, hopefully you can hear the Eminem lose yourself beat happening. You only get one shot to put this in the will before they die, right? So it has to be in the will before they die, in my opinion. Andrew, I'll talk you through that. But I think I wouldn't be trying to vary a testamentary trust will after someone's died to allow for this. So I've added in 2 more options in pink to represent what I think people who aren't in New South Wales should do. So if you haven't got a client who's obviously a New South Wales client or owns New South Wales property at this time of drafting the will, this is what I think I'm looking to do and for my clients, because I also don't want to and actually, I'll just say for my clients, I've stopped taking on mums and dads for a little while because I'm working on the art of estate planning exclusively. But I'm doing my cousin's will and various things, and I'm helping a lot of people with their will precedents. So this is what I think is best practice, without overcomplicating and trying to explain to your client in Western Australia why they have to give a shit about this New South Wales land tax issue, which is also a big thing. Okay, I think actually option 1 should also be pink as well, probably. If you're not a New South Wales practitioner, you could just start irrevocably excluding all foreign persons as beneficiaries of your trust, which I think at today's date is probably your best option, obviously making sure that that's appropriate. And if foreign persons may need to be beneficiaries, then maybe you go with option 2 for the more complex case. So let me just see. Vanilla, complex. I think that's probably the best you can do at the moment. Option 5 is the same as option 2, but we put it in the will in a much sneakier way. So I've said do it, but super proceeds trust style, which is basically, if you've seen my will precedent or a lot of them, you already set up an additional testamentary trust called a super proceeds trust, which the beneficiary classes are limited only to people who are death benefit dependents for tax purposes, right? Very similar to what we're trying to achieve here.